In this video, we'll continue our practice questions for the real estate exam. These questions are meant to help you prepare and pass the test on your first try. If you're just starting out, you'll find these questions are very similar to the writing style used on the actual exam. Today we'll be doing questions 21 to 40, but you can find 80 more in our exam questions playlist. Pause the video if you need more time to answer. Let's get started. Good luck.
21. A post office of unique design and construction is best appraised by which of the following approaches? Sales comparison approach, cost approach, income approach, gross rent multiplier approach. Explanation. Special purpose and public service buildings, as well as buildings of unusual form and construction, are best assessed using the cost approach, as there are few comparable sales for market data analysis and such properties typically generate no revenue. 22. An agent wants to show a home twice in one day. The second time does not require another call. Must call again only if the call is for a different buyer. Should contact the listing broker again. If she doesn't know who the listing agent is, she should call again to find out. Explanation. The answer is that the buyer's agent should call the listing agent again. Every showing needs to be confirmed by the listing agent. In many cases, software is used to communicate the showings with the sellers, and appointments are placed on a calendar. If there are no other appointments on the calendar, the homeowners will have no idea that someone's coming back to enter their home. 23. A contract of sale that is contingent upon the buyer's ability to obtain leases and advances. Void because it violates the statute of limitations. Unenforceable. Enforceable. Compensatory. Explanation. The answer is enforceable. The contract has a contingency and is conditional. It is enforceable, as the seller may seek specific performance if the buyer fails to complete the transaction and there is proof that a suitable lease could have been secured. 24. The covenant by which the grantor warrants ownership and possession of the property to be conveyed is referred to as the covenant of conditional ownership statement, continuing enjoyment, habendum, Sizen. The correct answer is Sizen. The covenant of Sizen is a promise from the grantor that they own and have the rights required to transfer the property in question. 25. An easement appurtenant cannot be terminated. May be terminated by the servient tenement. May be terminated by the dominant tenement. Will be terminated if abandoned by the servient tenement. Explanation. The answer is may be terminated by the dominant tenement. There are many ways an easement appurtenant can be terminated by the dominant tenement. They are, when the easement owner releases his interest through the use of a quitclaim deed, through a merger, by voluntary abandonment by the owner of the dominant estate, by the easement being taken by eminent domain, by loss by prescription or adverse possession, by expiration of the time period set for the easement, by cessation of the purpose for which the easement was created. Note that the dominant tenement may cancel the easement, but the servient tenement cannot, as it is irrevocable. 26. Existing first mortgages can typically be converted to second or subordinate liens by full payment on the first mortgage, recording of the first mortgage loan, a court order, a subordination agreement. The correct response is a subordination agreement signed by the first mortgagee. Subordination involves granting someone else priority. With a subordination clause, a lender waives their right to priority and allows the mortgage of another lender to take precedence. A subordination clause in a first mortgage, for instance, will convert that mortgage into a junior mortgage. 27. A mortgage on both real and personal property is known as personal mortgage, package mortgage, joint mortgage, blanket mortgage. The correct answer is a package mortgage. A package mortgage comprises real and personal property. A chattel mortgage is a mortgage secured solely by personal property. A developer uses a blanket mortgage when selling a development. They will sell a lot or newly constructed custom home and then repay the loan amount corresponding to the parcel sold. The blanket mortgage is analogous to a quilt. Every time a developer sells a parcel, they pay off a portion of the blanket mortgage. The remainder of the quilt and the blanket mortgage remain intact until each square or parcel is paid off and removed. 28. Whoever telephones anyone on the do not call list may be subject to which of the following penalties? Fines and imprisonment. Fines. Imprisonment. Revocation of his or her real estate license. Explanation. The answer is fines. Anyone who violates the law by calling people on the do not call registry may face a punishment of up to $16,000 per illegal call from the Federal Trade Commission, or even larger fines from the Federal Communications Commission, or FCC. License revocation and incarceration are not included in the statute. 29. A salesperson has presented an earnest money check to her broker for an offer that has an accepted contract. The broker should take the following actions. Deposit it immediately. Promptly return it to the seller. Return it when it's convenient for them. Give it to the seller as soon as possible. Explanation. The answer is to deposit it immediately. All trust monies must be deposited in accordance with applicable state law. However, as a general rule, they should be deposited immediately or as soon as possible within the state's limitations. 30. Trust accounts hold. Buyer's funds only. Seller's funds only. Funds for the firm, commissions, and other seller's bonuses. Funds not belonging to the firm. Explanation. The answer is that trust accounts are used to hold funds that do not belong to the business. Rents, security deposits, and earnest money are all examples of these. They may not include any commissions earned or monies held by the brokerage business. 31. The best definition of reconciliation is as follows. The appraiser's assessment of the highest and best use for a property. An average of the value from each approach to value. The appraiser's weighing of each property and approach to value. The method used to determine a property's most appropriate capitalization rate. Explanation. The answer is the appraiser's weighing of each property and approach to value. The final step in the appraisal process is reconciliation, during which the appraiser evaluates each approach to decide which is most relevant for the type of property being evaluated. In no case is averaging used in reconciliation. 32. The best way to describe replacement cost is as the cost of purchasing an equally desirable property, constructed of the same or similar materials. Cost of building a property of equivalent utility with the same or similar materials. Original cost adjusted for inflation. The expense of constructing an exact duplicate of the subject property. Explanation. The answer is the cost of building a property of equivalent utility with the same or similar materials. Replacement cost is the cost of a new building with the same functional utility. For example, you would choose to use the replacement cost method when rebuilding a police station that had a gym and community center attached to it. Instead of building with old materials, you would rebuild the property for the same purpose in the same location using modern supplies and technology. Reproduction cost is the cost of an exact replica of the existing structure. The reproduction cost method would create an exact replica using the same materials, same supplies, and exact same footprint of the buildings in that location. Note that in many cases, this would not be possible from a legal standpoint due to building materials that were used prior to 1978 and are now outlawed. That's one of the many reasons that the reproduction method is used more often than the replacement method. 33. The salesperson for Bobcat Realty has moved to 123 Realty. What happens to the listings the salesperson took at Bobcat Realty? They belong to Bobcat Realty. They belong to the salesperson, so they will transfer to 123 Realty. The listings are void. The listings transfer with the salesperson's license, so they belong to 123 Realty. Explanation. The answer on this one is that the listings belong to Bobcat Realty. The salesperson does not own listings, they take them in the name of or on behalf of their broker. One thing to note, this is the correct answer given the choices here, but in practice the salesperson's hiring agreement should dictate what happens with any listings that are in progress or on the market at the time of an agent's departure from their broker. 34. The seller engages a real estate broker to find a ready, willing, and able buyer to purchase the seller's parcel of real property. The seller executes and delivers to the broker an exclusive right to sell employment contract. A few weeks prior to the expiration date of the employment contract, the seller decides to revoke the contract before any sale occurs and prior to the broker finding a buyer ready, willing, and able to buy the property. The owner cannot revoke this contract because it is irrevocable. Can revoke this contract and will not be liable for damages to the broker. Will have to sell the real property at the listed price if the broker finds a buyer ready, willing, and able to buy at this price. Can revoke this contract but could be liable for damages. Explanation. The owner can revoke this contract, but could be liable for damages. No one can be forced to retain an agent he or she does not want, just like an agent can't be compelled to represent the seller he or she cannot perform loyally for. Thus, unless the agency is connected with an interest, either the seller or the broker may cancel the listing at any moment. However, if the broker incurs a loss, the broker may seek compensation in court. 35. The seller gave two firms an open listing on her home. Firm number 1 advertised the property but did not show it to any prospects. Firm number 2 showed the property to one prospect, but before the firm obtained an offer the seller sold it to a friend. Which of the following statements is correct? The seller owes firm number 1 for the cost of the advertising. The seller owes both firms a commission on the sale. Firm number 2 is due compensation for showing the property. The seller owes nothing to either firm. Explanation. The seller owes neither firm anything. In an open listing, only the person who procures the buyer is compensated. 36. All of the following are true of an exclusive right to sell listing contract except it must have a specified termination date. It is a bilateral, expressed contract. It must be in writing in order for it to be enforceable. It does not always require paying a commission. Explanation. The answer is it does not always require paying a commission. An exclusive right to sell agreement requires the owner to pay a commission regardless of who brings the buyer or procures the transaction. This is often confused with an exclusive agency listing which requires an owner to pay a commission only if the agents bring a buyer. In an exclusive agency listing agreement, the owners reserve the right to sell the property on their own and not pay a commission to the real estate agents. 37. The contract may be canceled by mutual agreement between the parties, by an attorney for either party, with 30 days' notice by either party, under no circumstances. Explanation. The answer is by mutual agreement between the parties. Mutual agreement or mutual rescission may be used to terminate a contract. A note for those of you who have purchased a home before, this question is speaking to a contract that has passed the attorney review stage and satisfied all contingencies. Canceling the contract at this point could only be done by mutual agreement. In some circumstances, attorneys will deliver notice of a contract being canceled due to contingencies or other allowable terms in the contract. That is not the intent of this question. 38. A month-to-month tenancy must include which of the following to be valid? All of these. Oral or written contract. Offer and acceptance. Consideration. Explanation. The answer is all of these. Since a lease is a contract, it must have consideration, offer and acceptance, legal object, and competent parties. If it's for less than 1 year, it can be oral. 39. When his nephew Fernando bought the apartment complex Marcus owned, Marcus granted him a general warranty deed. The deed was recorded by Fernando. Fernando later opted to sell the property back to Marcus. What would be the most effective way to accomplish this? Fernando must either prepare a new deed for Marcus or offer Marcus a reconveyance deed. Marcus requires a reconveyance deed, which Fernando must provide. Fernando must sign and return the deed to Marcus. Fernando must provide Marcus with a new deed and Marcus should record it. Explanation. The answer is that Fernando must provide Marcus with a new deed, which Marcus should record. This is a classic exam question that walks you into the woods and leaves you to find your way out. There are a bunch of spots to get lost or overwhelmed, so the best way to handle these questions is to break them down into steps. If you approach it step by step with what you know about deeds and conveying property, you'll find your way out easily. However, often nerves play a role and can make intelligent test takers question their knowledge. The answer to this one is simple if we keep it that way. The property was sold and transferred with a deed. The purchaser recorded the deed. To give the title back to the previous owner, the current owner must go through the normal process. Just like any owner who wants to sell their property, they must convey a deed at the closing. So when Fernando sells the property back to Marcus, he just repeats that process. He transfers the property via deed to Marcus, and Marcus should record it. 40. Which of the following would render a deed invalid if missing? Delivery. The grantee's capacity. Recordation. The grantee's signature. The answer is delivery. Deeds must be delivered to be valid, but delivery can occur without the grantee's signature. Revisit the 7 requirements for a valid deed if you're unsure of other possible deed conveyance issues.
That's the end of questions 21 through 40. If you need to practice a bit more, check out our exam questions playlist or head over to our vocabulary playlist to test your recognition of all the vocab terms you need to know to pass the exam. See you again soon.